red dot pops up on a stranger's screen, right where your porch light is. How did your life end up on a map, and who decided it belonged there? Then comes the question you can't shake. Who else is watching? If you hold a concealed carry permit in California, your name and license status may be queued for release by the Butte County Sheriff's Office after a records request from the San Francisco Standard under the California Public Records Act, CPRA, after the 2022 California Department of Justice exposure of CCW data. I don't gamble with rumors. I deal in law, proof, and your right to be left alone. Next, I'm going to trace the border you're not supposed to notice, the inches where public ends and private begins. On one side, light we need. On the other side, shadows we keep. Find that border, and you'll understand how some lists become accountability and others become a map. What actually happened and why it matters, verified, with a hint of mystery. There's a pause before the knock you don't hear. The kind of quiet that makes you wonder who decided your life belonged on a spreadsheet. Somewhere, a neat CPRA request lands on a county desk, routine ink, not so routine subject line, concealed carry CCW licensing data. Here's the ground truth. No rumor, no rage. CPRA starts from disclosure. If an agency wants to withhold, it must either cite a specific exemption or win under the Public Interest Balancing Test Government Code Section 7922.000. That means officials can't shrug and say, the law made us do it. They have to show their math. And with CCW, the math is not new. In Columbia Broadcasting System versus Block 1986, the California Supreme Court said CCW applications and licenses are generally public so the people can audit how discretionary permits are granted. But disclosure isn't a free-for-all. The court also required narrowly tailored redactions to protect privacy and safety. In practice, agencies often disclose names and certain licensing fields that illuminate how the program operates, while withholding home addresses and sensitive identifiers so records don't become a roadmap to your front porch. That approach also reflects CPRA's firearm license carve-outs, which recognize disclosure except where revealing details would expose when or where an applicant is vulnerable to attack, or disclose medical, psychological information. So where does that leave us? Citizens who carry lawfully right where the Constitution put us, with rights that don't require permission from outrage mobs or bureaucratic shortcuts. I'm not here to dramatize a records request. I'm here to enforce transparency with guardrails, yes, to oversight of government. No to doxing families who followed the law. Agencies have the tools: targeted redaction, documented balancing, line-by-line justifications. Use them. If an official claims, we had no choice, I want the section number, the exemption, and the analysis in writing. If they blackbar half the page, the same rule applies. Prove it. In a free country, accountability and privacy are not enemies. And for every lawful American who carries under the standard affirmed by the courts, the message is simple: we will defend both, calmly, firmly, and constitutionally. What CPRA compels and what it doesn't for CCW records. Let me set the ground rules plainly. Under the California Public Records Act, CPRA, records are presumed open. If a county releases part of your CCW file, it's not because they felt like it, it's because the statute says disclose unless the agency can point to a specific exemption or carry its burden under the Public Interest Balancing Test in Government Code, Section 7922.000. In English, if they want to withhold, they must show their math. Here's the backbone every city attorney cites. In Columbia Broadcasting System versus Block 1986, The California Supreme Court recognized a legitimate public interest in oversight of discretionary CCW licensing. Are permits issued fairly, consistently, without favoritism? To answer that, the court held that applications and licenses are generally public records, subject to targeted redaction to protect privacy and safety. That precedent didn't vanish when the CPRA was recodified. Agencies still must explain, record by record, why each line is released or withheld. So, what does that look like in the real world? Typically names, application dates, license numbers, and license status fields are candidates for disclosure because they illuminate how the government is performing a discretionary duty. But that doesn't mean everything goes out the door. Home addresses, phone numbers, medical or psychological history, social security numbers, unit identifiers, precise geocoding parcel data, and investigatory details are not fair game. When there's any doubt, the agency must run the balancing test. Does disclosure of this particular field serve accountability more than it risks privacy, harassment, or security? If the answer is no, the law allows and expects a narrow redaction. I'm not asking for secrecy. I'm asking for constitutional discipline. We can measure how a sheriff administers carry rights without turning lawful citizens into targets. That's the line the law draws. My job is to make sure they honor it, line by line, field by field. What must be redacted? Safety first and how the balancing test works. Before we talk about what can be released, let's anchor what must not become a roadmap to your front door. I'm talking about the pieces that turn a list into a target: home addresses, unit or apartment numbers, precise geocoding or parcel data, direct phone numbers, full dates of birth when not necessary for oversight, social security numbers, medical or psychological history, and investigatory details that would expose tactics, witnesses, or specific vulnerabilities. Those aren't convenience redactions. They are the guardrails that keep transparency from becoming doxing. Here's how a disciplined agency should do it, step by step. First, identify the responsive records. Second, isolate sensitive fields that could reasonably increase risk if published. Third, apply surgical redactions. Cut only what is necessary. Leave the rest. Fourth, write the justification, cite the statute, explain the risk, and record the decision. Finally, disclose the remainder promptly so the public can still see how the licensing program operates. That is transparency with safety, not against it. Now, the balancing test. This isn't a buzzword, it's a legal scale. On one side, accountability. The public's right to see whether CCW licensing is fair, consistent, and free from favoritism. On the other, privacy and security. The citizen's right not to have their home or family turned into a pin on someone's screen. The test asks a simple but serious question. Does the public interest in withholding specific fields clearly outweigh the public interest in disclosure of those fields? If yes, narrowly redact. If no, release. But explain why. Conclusory hand-waving doesn't pass. Documented reasoning does. Here's how that looks when I'm the one reading the production sheet. If a column helps the public audit performance, I keep it names and license status tell us whether the program is functioning, not who to harass. If a field points at a front door, I cut it, street numbers, unit identifiers, and precise zip +4 drift from oversight into targeting. And that's where I draw a hard line. I don't publish medical or psychological evaluations. That's not oversight. That's intrusion. And when an applicant explains a self-defense need, I'll allow a high-level summary at most, never the granular routine that maps a family's movements. That's the difference between sunlight on government and a spotlight on private life. Why Trust is Frayed, DOJ 2022. Breach and Fallout. The first breach isn't just a headline. It's the echo that hangs in every living room where a safe sits bolted to the floor. In June 2022, the state rolled out a glossy dashboard and, with it, exposed data tied to concealed carry permit holders. Names, licensing information, details that never needed to be public, were suddenly within reach. Later, the state confirmed the exposure and hired outside investigators. Their findings weren't a plot twist. They were a post-mortem gaps in training, gaps in process, and a failure to understand how dangerous just data becomes when it maps onto real people with homes, kids, and routines. That's why modern disclosures, no matter how by the book, arrive under a cloud. Once you've watched the lock fail, you don't accept "trust us" as a security plan. When a county now says, "CPRA compelled this," my answer is simple. Show me the section. Show me the redactions. Show me the balancing you actually performed. Because we've seen what happens when officials chase transparency, like a headline, and forget the human beings behind the fields. Let's be clear, I'm not against dashboards, audits, or oversight. I'm against careless exposure disguised as accountability. There's a disciplined way to do this. You disclose the performance of the government, how many applications, how long they take, denial rates, approvals by category, while protecting what turns families into targets, precise addresses, medical details, and anything that maps vulnerability. From day one, I demand discipline. Process first, no dashboard or download goes live until Council signs a memo that explains why each field belongs in public. Redaction by design address lines, unit numbers, and unique identifiers are stripped in the pipeline, not patched after the leak. Human factors: I train the people who touch the data. Software doesn't leak by itself. Workflows do. Accountability in writing when an agency claims disclosure is mandatory. I want the analysis published. What was considered, what was withheld, and why. If they want trust, they can earn it on paper. Rights, not fear actionable steps. I don't outsource my safety or my rights to anyone's press release. Here's how I move. Calmly and methodically, when CCW data is on the table. First, I ask for the paper trail, a short, targeted CPRA to my sheriff. What fields did you release? For what time frame? And under which sections? I ask for the redaction log and the balancing analysis. Not to pick a fight, but to see whether they're using the guardrails the law already gives them. If an official claims compulsion, I want the citation. If they claim discretion, I want the reasoning. That's not hostility, that's accountability. Second, I harden what I control. I route sensitive deliveries to a box, not a doorstep. I audit my online footprint the same way I audit a carry gun: slow, deliberate, and thorough. I keep serials, lot numbers, and photos in an encrypted vault. I review my insurance and safe storage plan like I review my carry fundamentals. Routine becomes readiness. Third, I practice disciplined disclosure. When I speak at public meetings or file comments, I do it as a citizen, not a data donor. I share principles and policy, not my daily route, not my kid's school, not my front door. The First Amendment isn't a trade-in program for the Second. Fourth, I push for the right metrics. If the government wants oversight, give the public performance data that actually exposes how the system works. Application volumes, processing times, denial grounds summarized by category, and appeal outcomes. That's sunlight on the institution, not a spotlight on your living room. Build redaction by design into every dashboard and publish the legal memo that explains the field list. Fifth, I back the people who do this right. That means sheriffs who write the balancing analysis, not just wave at it. It means lawmakers who codify address suppression and forbid geocoding citizens under the banner of transparency. It means supporting litigation that enforces Bruin while insisting that disclosure stop at the front step. Finally, I stay trained and civil. Freedom isn't loud, it's steady. We can defend carry rights and keep families out of the crosshairs. If we demand transparency with guardrails and refuse the false choice between liberty and safety, that's not fear talking. That's a free citizen reading the law and making it work the way it was written. We've walked the line the law actually draws oversight on one side, privacy and safety on the other. I'm not here to glamorize secrecy or excuse stonewalling. I'm here to demand what the Constitution promises: government accountability without turning lawful citizens into targets. That means narrow redactions, documented balancing analyses, and disclosures that illuminate how officials perform, not where families sleep. If your county says CPRA made us, ask for the section number, the exemption, and the memo. If a dashboard goes live, ask who signed off on the field list and where addresses were stripped out by design. Support sheriffs and lawmakers who do this right, and hold the rest to the text of the law. If this helped, share it, subscribe, stay trained, and stay civil. We defend both rights, to carry and to be left alone, by insisting on transparency with guardrails, every time, line by line,